Okay, good afternoon, everybody, and thank you very much for joining us this afternoon for the third session in our UNCRC series. And what we're going to be talking about today is the UN Convention on the Rights of the Child and what it will mean for local government. For those of you that don't know me, my name is Fiona McLeod. I'm a senior associate within our government regulation and competition team. And I'm joined today with my colleague Johanna Boyd, who is an associate also within Government Regulation and Competition team, but Johanna is also a barrister in England and Wales. I'm going to be talking today around just the general parts of the bill, and Johanna is going to be talking about some more specifics, particularly in relation to education, which she has a particular interest in. So as I mentioned, today is the third within the series for UNCRC. We have two more still to come next week, and the following Thursday after that, we have the UN Convention on the Rights of the Child. What will it mean for Scotland's charity and third sector? And then we've got a UNCRC debate hosted by our colleague Charles Livingston. So do hope that you can join us the next couple of Thursday afternoons as well to hear what we have to say about the final parts in the session. So just to touch on today's webinar, because that's why you've all joined in. So what are we going to talk about? So we're going to talk about what is the UNCRC. We're going to then touch on implementing children's rights in Scotland. For those of you that working within local authorities will know that particularly for social work services and education services within local authorities, children's rights are very prevalent. So a lot of what the UNCRC incorporates is already implemented in children's rights in Scotland. So I'll touch on a bit on that, on what you already do. We're going to talk particularly about the UNCRC Incorporation Scotland Bill. And we'll touch on the compatibility for local authorities to ensure that they're complying with UNCRC requirements, proceedings for unlawful actions and judicial remedies. My colleague Johanna is going to touch on the powers of the Children and Young People's Commissioner. She's also going to touch on some specific articles of the UNCRC that are relevant to local authorities, some budgetary concerns and reporting duties. So we've got a lot to pack in to quite a short period of time. So we'll just crack on. And I'll start by talking about what is the UNCRC. So the UNCRC was adopted by the General Assembly of the United Nations in 1989, and it was ratified by the UK government in 1991. It's the most ratified human rights treaty in the world and is an international human rights treaty designed to cover all aspects of children's lives. UNCRC sets out the civil, political, economic, social and cultural rights that all children everywhere are entitled to and is referred to by the Scottish Government as the gold standard of children's rights. Governments are expected to do what they can to implement the UNCRC by ensuring that all laws, policies and decisions comply with children's human rights. The UNCRC consists of 54 articles. Articles 1 to 42 contain the substantive rights and obligations which state parties must uphold and give effect to. And these include rights such as the right to life, survival and development, and the right to protection from violence, abuse or neglect, the right to education that enables children to fulfill their potential, and the right to be raised by or have a relationship with their parents, and the right to express their opinions and be listened to. The rest of the articles, articles 43 to 52, are in relation to procedural arrangements for signature, ratification and amendment of the UNCRC and the creation of the Committee on the Rights of the Child and reporting processes. We will come on to touch more particularly in detail in relation to the articles of the UNCRC, in relation to what we think are important for local authorities to be aware of. But just now, just to kind of touch on the generalities of the Act, there are four articles in the UNCRC which are known as the general principles. And these assist in interpreting the other articles and play a fundamental role in realising all the rights in the UNCRC for all children. And the general principles include non-discrimination, which is Article 2. So Article 2 provides that all children have the rights set out in the UNCRC, and individual children and young people shouldn't be discriminated against when these rights are realised. The best interest of the child, which is Article 3, Article 3 provides that in all actions concerning children, the best interest of the child should be a primary consideration. So that's actually slightly less than what a lot of you will do if you're working in local authorities and social work, where it's of a paramount consideration rather than a primary consideration. And I'll touch on that as we talk about some of the existing legislation in place relating to children's rights. Article 6 is one of the general principles, and that's right to life, survival and development. And then a right to be heard, which is Article 12. And Article 12 provides that a child who's capable of forming his or her own views should have the right to express those views freely in a manner affecting the children, and the views of the child have to be given due weight in accordance with their age and maturity. And we're going to have a little look as well, in particular, at Article 12 a little bit later on. So the UK government ratified the first and second optional procedure relating to issues such as the involvement of children in armed conflict and the sale of children, child prostitution and pornography. And a third optional protocol, which allows complaints to be made by the CRC, has not yet been ratified by the UK government. So at present, the UNCRC and the ratified protocols apply in international law, and the UK government and governments of devolved nations are expected to do all that they can to implement the provisions of the UNCRC. However, the rights and obligations under the UNC are not directly enforceable by the courts in the UK. So if the UNCRC Scotland Bill comes into force, Scotland will be the only jurisdiction in the UK where the majority of rights and obligations under the UNCRC will be enforceable by the courts. Now, many of you will know that there is a challenge to the Supreme Court, which I'm going to touch very lightly on in a couple of slides' time. But in the event the bill does come into force, the rights and obligations under the UNCRC will be enforceable in Scotland. So if we could just move on to the next slide. Then we're going to just have a little look at some of the legislation that implements children's rights in Scotland to date. So as I mentioned, many parts of the CRC have been reflected in Scots law previously. And these include through specific pieces of legislation and policy documentation. So, for example, the Children's Scotland Act 1995 provides a significant part of the legal framework for child welfare and protection in Scotland. And it already embedded a number of the principles between the UNCRC. So, for example, Section 11 of the 1995 Act is an example of legislation which goes further than the UNCRC, because Section 11 of the 1995 Act provides that when considering whether or not to make an order on matters such as child contact and residence and parental responsibilities and rights, the court must regard the welfare of the child concerned as its paramount consideration. So that compares to Article 3 of the UNCRC that I just mentioned, which provides that the best interest of the child should be a primary consideration when considering all access concerning children. So those working within social work services were well aware and well versed on acting with the paramount consideration of the best interest of the child. Some other acts to mention is the Standards in Scotland Schools Act 2000. That sets out the provision of school education, specifically relating to children's rights and the duty of the Education Authority. The Children and Young People Scotland Act embeds the principles of Article 3, Article 12 and Article 42 of the UNCRC. And the 2003 Act created the post of Commissioner for Children and Young People in Scotland, with the general function of promoting and safeguarding the rights of children and young people. Also to mention is the Mental Health Care and Treatment Scotland Act 2003, and Section 2 of the 2003 Act makes specific provision as regards to securing the welfare of any child in respect of care treatment given under the Mental Health Act 2003. The Education Additional Support for Learning Scotland Act 2004 embeds the principles of Articles 6, 23 and 29 in the education system. And my colleague Johanna Boyd is going to talk a little bit more about the specific articles for the education system a little bit later on. So as you can see, the number of the principles of UNCRC are embedded within existing legislation. And in relation to those that work within social work, children and family services in local authorities, they'll be particularly aware of the Adoption Children Scotland Act 2007. And that modernised the system of adoption in Scotland to provide long-term security for children who cannot live with their families, and embeds the principles of Articles 3, 7, 8, 9, 12 and 21 into the adoption system. In addition, we've got the Children Hearing Scotland Act that reformed the children's hearing system and embeds principles of Articles 3, 4, 6, 8, 9, 12, 25 and 40. And most recently, the Children's Scotland Act 2020 enhanced how the voice of the child is heard in family cases. So a lot of the principles of the UNCRC have already been incorporated, but what's different now if the UNCRC Scotland Bill is incorporated into Scots law is that it won't just be to have due regard to the principles of UNCRC, there will be a requirement to comply. The other thing that I just wanted to touch on, and it's not a piece of legislation, but the rights and obligations contained in the UNCRC are also given effect through a range of policy and practices in Scotland, and in particular, the Getting It Right for Every Child policy is the national approach in Scotland to improving outcomes and supporting the well-being of children and young people by offering the right help at the right time from the right people. And that was drafted with particular consideration being given to the UNCRC. So in Scotland, there have already been quite a lot of consideration given to the principles of the UNCRC. So hopefully for many of you that work within children and family services, that this won't have much of an impact on your day-to-day working lives. However, I will talk about some articles that we do need to have some consideration to. But we're just going to pause there because it's a really, really quick run through of the current legislation. And we're going to run a poll. So if we can just launch our first poll, please, to see how much of the audience have been involved in being asked for support or advice regarding the impact of the UNCRC bill in relation to council services. So if you'd answer yes or no, and if when you're answering yes or no, can you confirm whether this was in relation to social care, education, or another service area within local authorities? Okay, so they're coming in now. Okay. So we've had the poll results come through. So the majority of people have been asked for support or advice regarding the impact of the UNCRC bill in relation to council services. And quite interestingly, so we've got 46% social care, 38% education, and 69% other service areas. So those that are interested and are willing to do so for other service area, if they could just put a little comment in the Q&A what service areas you have been asked about it in relation to, then we might be able to touch upon that at the question and answer session at the end. I also can see that I think that somebody had raised their hand. So I think Carla Roth might have, did you raise your hand, Carla? Do you want to ask something just now? No, maybe speak to Carla a little bit for later on. Okay, so we'll stop sharing these results and we will keep cracking on because I'm conscious of time. Oh, no problem. Carla said she hit the wrong button. So we'll just keep going. So the UNCRC and the Incorporation Scotland Bill. So on the 1st of September 2020, the UNCRC Incorporation Scotland Bill was introduced in the Scottish Parliament. The intended purpose of the UNCRC bill is to incorporate the UNCRC into law in Scotland. And on the 16th of March 2021, Scottish Parliament unanimously passed the UNCRC bill. And by incorporating the UNCRC into Scots law, it seeks to ensure that, among other things, public authorities are legally required to respect and protect children's rights in all the work that they do. So in particular, the bill directly incorporates the UNCRC as far as possible within the powers of the Scottish Parliament. It makes it unlawful for public authorities and anyone undertaking functions or providing services to children with public money to act incompatibly with the incorporated UNCRC requirements. Gives power to the Children's Commissioner to take legal action in relation to children's rights. It requires ministers to produce a children's rights scheme, setting out how they'll comply with children's rights and to report annually. It requires listed public authorities to report every 3 years on how they comply with children's rights. And it gives children, young people and their representatives the right to go to court to enforce their rights if necessary. So I'm going to talk a little bit about enforcing the rights. Johanna will touch on the Children's Commissioner's powers, the Children's Rights Scheme and the reporting duties of local authorities. For those of you that were unable to attend yesterday, our chairman, Christine O'Neill, held a question and answer session with the Children's Commissioner in relation to the UNCRC and a number of school pupils. We will send around the link in relation to that, but for those of you that are interested and didn't make yesterday, it would be certainly worth listening to what the Commissioner has to say. The approach that's been taken in relation to incorporation of the bill is a direct approach. So that does not mean that further provision to give effect to children's rights in Scotland is not possible or desirable. And indeed, the Scottish Government considers that by incorporating the UNCRC and optional protocols in full and directly, as far as possible within the powers of the Scottish Parliament, Scottish ministers will be under a continuing obligation to review legislation, policy and practice, and to consider what further provisions are necessary to ensure that children's rights are fully respected, protected and fulfilled in Scotland. So if we just move on to the next slide, which will talk about the compatibility with the UNCRC. So, excuse me, Section 6 of the bill makes it unlawful for a public authority to act or fail to act in a way that's incompatible with UNCRC requirements. Section 6 of the bill does not provide an exhaustive list of public authorities to which this section applies. However, for those that are on the call today from local government, it will include you, so you should be aware of what Section 6 says. And Section 6 gives a meaning of public authorities. So, for example, bodies to which the compatibility duty applies. It's been drawn intentionally wide so as to ensure that the duty applies to all public authorities in respect of which it is within the power of the Scottish Parliament to apply the duty. So this will also include Scottish ministers, Scottish courts and tribunals. And similar to the Human Rights Act, the definition of public authority will not include so-called include so-called core public authorities, such as local authorities and health boards, but also other bodies, including private bodies when they're exercising functions of a public nature. So it is very wide-ranging. And just to amplify how wide-ranging it is, the policy memorandum for the UNCRC bill at paragraph 124 states that the functions of public authorities to which this section will apply should apply to the fullest extent possible within the Parliament's powers. And this will encompass the devolved functions of public authorities. So it's important to be aware who this will affect. And if we move on to the next slide, we're going to just touch on what the effect is then of that, of Section 6. So public authorities really should consider the requirements of the UNCRC in all decision making. And the manner in which public authorities make decisions may engage in rights under the UNC. For example, the suggestion that public authorities' decision making curtailed a child's freedom of speech and freedom of expression, Article 13, failed to have the children's best interests a primary consideration, Article 3, or failed to give weight to the views of the child, Article 12. And Section 6 imposes a duty on public authorities to comply with the UNCRC bill. So as I mentioned earlier, this then goes beyond simply requiring public authorities to have due regard to the UNCRC, which it was previously. And the consequence is that public authorities must therefore ensure that outcomes are compliant with the UNCRC. So, for example, Article 3 provides that in all actions concerning children, the best interests of a child shall be primary consideration. The CRC General Comment number 14 of 2013 provides guidance on how Article 3 should be interpreted. And the General Comment explains that actions includes decisions, conduct, proposals, services, procedures, and other measures relating to children. And furthermore, actions in Article 3 encompasses inaction or a failure to take action and omissions. So for local authorities, this doesn't only just include services that are directly related to children, such as education or children and family service. This will also include services such as your housing service, any development, data protection, because the rights of privacy is an article within the UNCRC. So it is really wide ranging for local authorities that will cover probably across the majority of the services that are provided. So who can raise an action? So a child or a person acting on behalf of a child can raise proceedings against a public authority, alleging that when the public authority made a decision on the criteria or the process for awarding certain criterias, the best interests of the children were not primary consideration, or alternatively, there's been another breach of an article within the UNCRC. And what we do want to flag at this time, and a lot of this is going to be, to be confirmed as matters continue within the future, but the articles of the UNCRC are drafted in really wide and general terms. And the wide and general terms of the UNCRC will afford Scottish courts a degree of latitude when interpreting the UNCRC. But what is clear is that the best interest of the child will not need to only be a primary consideration. They will need to be not the only consideration. It has to be that they are taken into consideration with all of the rights under the UNCRC and ensure that that's embedded in public authorities' decision-making processes. So if we move on to then what will happen if somebody raises an action within the court system. So this is all covered within Section 7 of the bill, and it applies to a public authority that has acted or proposes to act in a manner that's unlawful by virtue of Section 6. So under this section, a person could raise proceedings in a court or tribunal against the relevant public authority, alleging that it's acted or proposes to act in a manner which would be contrary to the requirements of the UNCRC. So I think it's really important to know that it doesn't have to be retrospective action. It can be something that the local authority is proposing to do, which would be in breach of one of the articles. So under the UNCRC bill, a person will have 1 year to raise the action, or alternatively, if it's going to be by petition for judicial review, they would have 3 months from the date that the act complained of took place. However, this timescale only starts ticking to an act which takes place once the UNCRC bill comes into force, so it's not particularly relevant at present. However, what does also have to be noted is that any time during which the person making the claim is under 18 years old, then that does not include the computation of the 1 year time period. So if they're under 18, then there is no time limit for raising proceedings. So that's something to be particularly aware of in children and family services and education services. And if we just move on to the next slide, we're going to talk about some of the judicial remedies. So what will happen if a court or tribunal finds that public authority has acted unlawfully under Section 6? Well, it can make quite a range of orders. And Section 8 of the bill expressly discusses some of the orders that the court or tribunal can make. So the court or tribunal can grant any relief, remedy, or make any order that's within its powers to grant or make. And then the rest of the section is concerned with damages as a remedy. And the Scottish Government, in drafting the bill, recognised that it's important that damages are available for breaches of human rights and that these may be appropriate in circumstances to ensure children and young people have access to effective remedies under the bill. And that's in line with the views of the CRC. And the Scottish Government believes that the principle of just satisfaction, and that's a principle that applies to damages in relation to human rights claims, is a helpful framework which can be utilised by the courts when considering what remedies will be awarded in effect of breaches of children's rights. And Section 8 of the bill requires courts, when considering whether to award damages or the amount of damages, to consider whether awarding such damages is necessary to provide just satisfaction to the claim. In addition, where court action has been brought which involves a claim that a public authority has acted or proposed to act in a way that's incompatible with the UNCRC, the requirements and the court is considering what kind of order it should make in relation to the breach, then they will have to provide the child with an opportunity to express their view on effectiveness of what is proposed. And it was noted in Parliament that a requirement to obtain a child's view in this manner is kept with current child law in Scotland and also Article 12 of the UNCRC. So it's interesting to note that Parliament has included the words insofar as practicable in section 8A. Article 12 of the UNCRC does not include the words insofar as practicable. However, this addition arguably demonstrates a degree of acceptance by Parliament that there will be situations where Article 12 may not apply, but it may apply, but it may not be practical to obtain the views of the child. So it will be dependent on very much on a case-by-case basis whether the views of the child will be heard and taken into consideration. So that is a quick fly through of the UNCRC Scotland Bill and what the UNCRC is. If we just move on to the next slide, I just want to touch very, very quickly on the constitutional context. Anybody that has been following this bill will be aware that the UK government has produced a challenge to the UNCRC Scotland Bill. And just to give some context around that, the Scottish Government's stated intention was to take a maximalist approach to the UNCRC bill. And to achieve this, the UNCRC bill sought to incorporate the rights and obligations under the UNCRC using the corresponding protocols to the fullest extent possible. It's not possible for the Scottish Parliament to incorporate parts of the UNCRC and the relevant protocols that relate to reserve matters, and that's matters which are outside the legislative competence of the Scottish Parliament by virtue of the Scotland Act 1998. So accordingly, the UNCRC Scotland Bill will incorporate Articles 1 to 42 of the UNCRC, Articles 1 to 11 of the first optional protocol, and Articles 1 to 7 of the second optional protocol. The UNCRC bill has not yet received royal assent, so it's not law. And as I mentioned, there has been a challenge by the UK government to the UNCRC Scotland bill. Now, as I mentioned, this is number 3 of 5 seminars in relation to UNCRC. In the first seminar, our colleagues Charles Livingston and Christine O'Neill discussed this particular constitutional requirements and the aspects of this in the first session. And what we're going to do, rather than go through that because it's particularly detailed, is that we will send you a link to the first session when we're following up on this session, in the event that anybody does want to have a listen to that and listen to the constitutional impact that this may have and what certain things that have to be taken into consideration. However, in very brief, the UK government has expressed concerns about the bill because it considers that, as passed, the bill attempts to impose obligations on the UK government and could interfere with Westminster Parliament's power to legislate in Scotland. So the bill's been referred to the UK Supreme Court and a hearing's been assigned for the 27th and 28th of June this year. And for those that will be interested in it, it will be available to watch live and will be streamed live from the Supreme Court. And what Christine will often talk about is that it's a good chance to, if anything, have a look at some of the curtains behind the justices when you're having a watch, which is always quite interesting to see them all still streaming from home. So that'll be quite interesting, 27th, 28th of June, and then we'll see what will happen after that in relation to implementation of the UNCRC Scotland Bill. And if we could just finally move on to the next couple of slides. So that's a real whistle-stop tour of the UNCRC Scotland Bill in its general terms. Now to just have a look at how this is going to really affect local government more specifically. Johanna's going to talk about this in a lot more detail, but what I just wanted to touch on was really the role of social work and the UNCRC and how they interplay with one another. So what does it mean for local government? An obvious service that's going to be affected by the UNCRC is social work, children and family service. And at its core, social work is about promoting all human rights, and social workers are incredibly passionate about advocating for the rights of children and families and ensuring that children and young people are safe, healthy and happy. And as I mentioned, the incorporation of UNCRC means that this is not just an exception, but a requirement, and social workers will become even more important in terms of advocating the rights for children with whom they work. The social workers are going to have to advocate for children's right, not merely in terms of protection and welfare, but in ensuring children and young people know their rights and understand what having their rights in law means for them. Social workers will now be promoting cultural change, whereby the voice of the child takes on a stronger role. The incorporation of the articles can mean at times that children can decide not to engage with social work. And this means that decisions will become more complex, and social work services are going to need to be able to work through and take the time to understand how this is going to affect their services and how they can engage with children in the decisions which affects them moving forward. So in particular, with reference to that, is the Article 12 of the UNCRC. And that states that every child has the right to give their views in matters affecting them. The views should be listened to by those who can influence and bring about change and required to maximise well-being. But as I mentioned, the Children's Scotland Act 2020 already aimed to bring the law in relation to children's rights further into line with the UNCRC. And in particular, the 2020 Act makes sure that children's views are being heard in family court cases, and children's hearings and the best interest of the child are at the centre of those cases. So in particular, with reference to permanence orders or permanence orders with authorities to adopt. Moreover, the shift from a duty to give due regard to a duty to comply will necessarily and positively shift the balance of power from organisations to children and young people. And local authorities, among many other public organisations, will need time to prepare for that shift, thinking through and proactively making changes to systems and practice, rather being forced into change through threat or outcome of legal proceedings. So it's hoped that there will be given some implementation time in order for certain considerations to be given to the full articles of the UNCRC. But just moving on to the last slide that I'm going to be talking to, you'll be glad to hear that I'm going to be taking a break. We wanted just to flag some other articles of relevance to social work services to be aware of. We split these into 3 categories. So family, environment and alternative care, basic health and welfare, and violence against children. So just touching on family, environment and alternative care, these articles relate to the role of families or care arrangements in the development of children. And that includes respecting the role of the parents or other guardians and the support they should receive to help raise their children. And that's Article 5. It also includes making sure that children are not separated from their parents against their will, unless it's in the child's best interest, and that's Article 9. There are rights regarding family reunification, which is Article 10, measures to prevent abduction and non-return of children, Article 11, and recognising parental responsibilities, Article 18. The Convention also provides that children have the right to be well looked after when they're not able to live with their parents, and that's Article 20, and that adoptions promote the best interest of the child, and that's Article 21. And finally, Article 27 is that children have an adequate standard of living. So all of these considerations have to be taken into effect moving forward. In particular, in relation to foster care standards, the standard for foster care was published in 2017, developed by the SSSC and closely linked to GIRFEC. The standard for foster care is intended to make sure that foster carers are confident and well prepared for their role and in a good position to support children in their care, and that relates to Article 5 of the UNCRC. So some relevant articles to consider with basic health and welfare. These articles aim to make sure that children have the highest possible standard of health and can access relevant healthcare services. The group of rights cover the right to life, survival and development, Article 6, responsibilities of parents and governments, Article 18.3, children with disabilities, Article 23, health and health services, which is Article 24, social security, Article 26, standards of living, Article 27, and drug abuse, Article 33. And last but by no means least, we clustered some of the rights together around violence against children. And those that work with children in local authorities in particular are well aware that children are among the most vulnerable in society and should be protected against all violence in all of its forms. And the relevant rights require governments to take all reasonable steps to protect children from violence, including physical, mental, and sexual abuse and neglect and maltreatment. The UNCRC also requires governments to promote recovery after abuse or violence and ensure that children are not subject to cruel, inhumane, or degrading treatment, and make sure that discipline at school conforms with the ideals of the UNCRC. So relevant articles for this are articles 19, 28, 37 and 39. And social work services really provide a fundamental role in making sure that children in care are protected against violence. So that's a really quick whistle stop tour in relation to some of the articles that we think are important for consideration in relation to, particularly in relation to social work with children and family service. We're going to now pass over to Johanna, who's going to chat a wee bit more through the education service and also some other requirements placed on local authorities. Thank you, Johanna.
Thanks very much, Fiona. And we're going to start my part of the presentation with another poll, please. So the next question that we have for you is, to what extent has your council prepared for the impact of the legislation that Fiona's just taken us through? Is your council well prepared, somewhat prepared, unprepared, or do you simply not know? And this is quite interesting in the context of the previous question that we had, an answer that we got, that actually 46% of our attendees today had not been asked a question about the UNCRC. So we are gathering together the responses which are coming in now. And I understand you're now viewing the poll results, which show us that 11% of you feel that your council is well prepared, a third of you're somewhat prepared, 11% unprepared, and actually quite a high percentage of you are just unaware, don't know, not sure as to the extent to which the council is prepared. I think that's really interesting that we've got an equal balance between those feeling well prepared and those feeling unprepared. But as I say, a very high percentage that simply don't know. So we'll stop sharing those results. We'll have one final question for you at the end of the session. Now I'm going to turn to talk about the articles of the UNCRC that relate to education. And again, forgive me for those of you that deal in education law, you will be likely to be very familiar with these. But it's worth just reminding ourselves that the key provisions are articles 28, 29 and 42. 28 sets out the basic right for our children and young people to a free compulsory primary education, a variety of secondary education, and we must of course ensure that school discipline respects children's dignity and the rights that are actually contained within the UNCRC. Article 29 is very interesting to look at, again, very broad, as Fiona's touched upon. It's about development. It's about developing talent, personality, and our children and young people's abilities to their fullest. And it does go on to describe in quite a bit of detail exactly what that might look like. So encouraging respect for human rights, parents, other cultures, the environment. And I thought the third bullet point was particularly interesting in terms of the breadth that the UNCRC expects in preparing our children and young people for what's described as a responsible life in the spirit of peace, tolerance, equality of sexes, friendship, amongst all of those groups that are described there. The final article, the knowledge of rights, governments have to ensure that children and adults know about the UNCRC, and indeed there is provision within the financial memorandum of the bill to ensure that that happens through various media campaigns. And indeed, as you'll be well aware, there's been a lot of press around this bill because of its significance and importance. Now, if you want to learn a bit more about the articles that are specific to education, I would very much recommend to you going onto the UNICEF site. It stipulates the Committee on the Rights of the Child and a general comment that it issued back in 2001. But what that comment does is it goes into quite a bit of detail as to the aims of the articles, and it gives a very clear overview as to what the right to education actually means in practice. And again, as Fiona's described in social care, in education, much of the goal that sits behind the articles that relate to education are already embedded in Scots law through the various legislation that I'm going to go through briefly in a moment. But still, I think it is worthwhile just looking back and looking at exactly what those expectations are in relation to this convention. And I think it's also worth adding that it's really important to remember that we don't just look to those articles that relate to the area that we might be advising on or providing a legal note on. The convention really does have to be seen as a whole, read in its entirety. So articles 28 and 29, for example, we might also be thinking about, well, what about Article 31 and the right to leisure and rest and play? What about the protection of a child's privacy? Does that come into play? So it's very important when we're thinking about how this convention is going to operate in practice, that we're thinking about all of those rights and how they sit together. If we can move on to the next slide, please. We see I've put up there some of the existing legislation, and indeed Fiona's already touched on quite a few of these acts, and you'll be pleased to hear I'm not going to repeat reference to those. The ones I think that are worth highlighting on this slide relate to the standards in Scotland schools, so that embedding those principles of Article 29 that we've just highlighted, talking in that act about the provision of school education specifically relating to children's rights and the duty of the Education Authority. Again, you'll be well aware that the Commissioner for Children and Young People Act, embedding those articles there, 3, 12 and 42, also gave us the post of the Commissioner, importantly, and the Education Additional Support for Learning Scotland Act of 2004, that again embeds the articles that are highlighted there, 6, 23 and 29, but also is the legal framework, as you'll be well aware, that underpins the system for identifying and addressing the specific needs of our children and young people that have additional support needs. So moving on to the next slide, again, we've grouped this part of the education legislation that exists in Scots law between 2010 and 2016. And again, 2014 Act, you'll all be very well versed in it, introducing the GIRFECT agenda, getting it right for every child, creating specific reporting duties on public authorities. Also very important not to forget the Equality Act 2010. It had its 10-year anniversary very recently, and that embeds the principles of Article 2, so non-discrimination into our education system. If you're looking at the Equality Act, then you should be looking at Part 6 that deals with education, Chapter 1 specifically dealing with schools, the Act making it unlawful for the responsible body to discriminate against, harass, victimise a pupil or a potential pupil in relation to, for example, admissions, in the way that that local education authority might provide education, or in relation to a pupil accessing any facility, benefit or service. So they're the sorts of things that you'll be familiar with coming up underneath the Equality Act of 2010. Worth mentioning the Education Act of 2016, of course, because that specifically refers to the socioeconomic background of children, children with additional support needs, and again, further reporting duties highlighted there. Of course, the again, also not worth remembering or not forgetting rather that the socioeconomic duty is set out also in section 1, the Fairer Scotland duty under the Equality Act, and any strategic decision that local government is taking should be seeking to reduce those socioeconomic inequalities as they exist within that council's communities. So if we can move on from our existing legislation within Scotland to think a little bit more about the children's rights scheme as it's set out within the bill, and we've given you the provisions there, sections 11 to 14. Now, the children's rights scheme is for the Scottish ministers to make, and it is for them to set out within those arrangements and ensure that there is compliance with the compatibility duty that Fiona's described, and also that they secure better or further effect of the rights of children. Now, this scheme is intended to be very broad. It has to include, for example, arrangements for ministers to ensure that children can participate in the making of decisions that affect them and have access to both support and representation. It also includes expectations of others that go beyond Scottish ministers. It's a scheme that has to be reported on annually and can be updated as and when that is thought appropriate to do. Looking then next to, I think, what's going to be a very important element of this scheme, that is the child rights and wellbeing impact assessment. So that's set out in section 14. And one of those assessments has to be undertaken when Scottish ministers are taking a decision, again, of a strategic nature, or when they are considering either primary or secondary legislation. And again, I'm very alive to the fact that many of you will be well used to undertaking various sorts of assessments, whether that's this sort of assessment or an EQIA, an equality and impact assessment, for example. There is, however, very helpful guidance. It's guidance directed to Scottish Government officials on these CRWI assessments, and I would certainly recommend that to you. It also has a template within that guidance. It's also important just to bear in mind that the policy memorandum that accompanies the bill, paragraph 155, sets out the Scottish Government's expectation around these assessments, that they are rigorous, they ought to be rigorous, so not ticking of boxes. That's never what these sorts of assessments ought to be, and that they apply at all levels within all spheres of government, and they will be an important part of demonstrating compliance, both with the section 6.1 compatibility duty and with how your individual council is both respecting, promoting and fulfilling children's rights in practice. So let's move on to the next slide, which again, you'll be very alive to and keen to know about. That's what is a council's reporting duty under these new provisions. What does it mean that that we have to do as a council in terms of demonstrating compliance with the UNCRC? So as we say on the slide there, every 3 years, local authorities will be publishing a report. It will look back and it will look forward. So what's happened over the last 3 years? What actions does the council intend to take? How can it demonstrate compliance? How has it secured or bettered or given further effect to the rights of children? And again, interestingly there, the report has to be published in a version that children can understand. And we see under the Acts provisions relating to guidance. So Scottish ministers will be issuing councils with guidance on how to produce those reports. And just interesting to note there that there is a parallel duty on the Scottish Parliament to publish an annual report. So we said, if we go into the next slide, please, we said that we would talk in a little bit more detail about the role of the Children and Young People's Commissioner and the powers of the Commissioner under the UNCRC bill. And as we say there, his or her, currently his, powers are strengthened. Section 10 of the bill amends the Act that I referred to earlier, the 2003 Act, and the Commissioner now has the power to bring proceedings in a court or tribunal against a public authority for non-compliance. And the Commissioner will also have the power to intervene in proceedings where a person has made a claim that a public authority has acted unlawfully. And there's no requirement, interestingly, that a complaint has to be raised in order to trigger the Commissioner using those powers. Now, for those of you that attended the session yesterday, where we had the Commissioner with us and some really inspiring young people from various all secondary schools actually from around Scotland, he was describing what he thought was going to happen after this bill becomes an act, and how litigious he anticipated being. So that was really quite interesting. And in his view, there is not going to be a huge rush to the court, certainly not from his offices. And he was very clear that, and again, anyone involved in litigation is always very alive to this, that it's often far preferable to avoid having to litigate in the courts, particularly around sensitive issues that can arise in and around children and young people. That's not to say, of course, that he would not exercise those powers in the appropriate cases and where he felt moved to do so. But what he was very clear about and what he is anticipating is a change in that decision-making process, a change in the culture of public authorities. And he specifically talked about the use of the assessments that I was referring to on the previous slide in terms of working with public authorities. Obviously, that includes local government. And he specifically mentioned, as I say, working on these assessments. So again, for me, that just really highlights the attention that local government ought to be paying to these assessments and how they are undertaken. In terms of specific change that the Commissioner highlighted, he anticipated that in being around public authorities actively seeking out the views of children and young people and involving them, which he pointed out that question of engaging young people, engaging children really does flow throughout all of the articles. It flows throughout the entire convention. So again, that's something that I think local government has much experience in, perhaps more so than other public authorities. But again, it was interesting to listen to the Commissioner with that, highlighting these specific areas. He also highlighted, and I think it's worth mentioning, the involvement of children and young people in service design. So again, I thought that was where many of you may be involved in looking at the impact of service redesign. Again, just very important to be alive to this bill and the fact that there is an obligation to be engaging with children and young people when thinking about the redesign of council services. So I'd like to move on to the final slide, which is always at the forefront of the minds of public authorities and in particular of local government, and that is money, it's finance, it's budgets. So what does this bill provide for in the financial memorandum? Well, £2 million over 3 years. And just to be clear, that's for the entirety of the bill and all those that are affected by it. And I would recommend to you having a look at the financial memorandum because it's worth reading as to how the figures that we've put up there on screen break down. So empowering children to claim their rights, 1.25 million for that. Embedding rights in public services, 835,000. The memorandum specifically highlights the local authorities should consider one-off costs for updating training materials. Obviously, a lot of this training and reporting procedures you will already have in place, but there may well be a need to update, to review, to amend in light of this bill. As Fiona's already mentioned, it's a maximalist approach to the incorporation of the UNCRC. So that has led, in the consultation responses that came through, to some speculation that there may be a considerable quantity of litigation as a result of the UNCRC bill coming into Scots law. So the and final point, I think you'll have already anticipated this. Of course, it does not fully account for the cost to public authorities to fulfil those obligations in terms of access to children's rights. Now, with the question of training and future amending of some of your policies and internal training materials, etc., in mind, we have our final poll question of the day. So if we could run that, please, now. And the question is this: do you have any UNCRC training sessions planned within your council? You may have had some already, but in terms of what's coming up, we'd be interested to know. So the numbers are coming in. I don't think you can see, I think, yes, you can see them now. So we've got 14%, yes, have training coming up, but the vast majority of you are either no, we don't, or we don't know. So that's very interesting. I think we can stop sharing those results. And I'm pleased to say, with 5 minutes to go, we do have enough time for some questions. And I can see that there's one question that's come in, and Fiona, I think this is a question more directed towards your part of the session. And it is, how do you think, Fiona, that the courts will interpret the UNCRC?
Yeah, what I would say is that the moment there's quite a degree of latitude that are given by the courts in relation to this. And what we have seen is that the courts have incorporated some consideration to the UNCRC when giving due regard to that. And I think they will continue to talk about that. I'm conscious of the time, so I don't want to go into the case law in too much detail. So what I would suggest is that in Charles and Christine's webinar that I mentioned, Christine does talk about some cases that directly considered the UNCRC when coming to their judgment. And I would recommend for those that are interested, more particularly in relation to answers to that question, to have a little listen to that webinar. In general, it's very interesting, but we'll also give you some more detailed information in relation to the specific case laws.
Yes, yeah, no, that's really helpful. And I think it is important just to say that we are in something of new territory.
Yeah.
Just in terms of the way in which the bill is framed, and as you very clearly set out, not due regard, but incorporation directly of those terms, and what will that mean? There is a further question, and I think it's possibly one more directed to me, and it is, do you see the UNCRC as being used as a tool to challenge budget decisions that might affect children and young people? And I think that that's a really helpful reminder with regards to some of the processes that I imagine all, certainly most, of the councils on the call will be engaged in, and that is around participatory budgeting. I think what's absolutely clear from looking at both Article 12 and all of the commentary that we've had today on the webinar, and indeed any reading that you do around this subject, is taking on board children's views. So I think, you know, if you have a proposal, and let's assume it is for a cut or a reduction in a service area, and you know that that is going to affect children and young people, it might be something very obvious like a cut to additional support need teachers, or a change to something very controversial like music tuition and music provision. Then I think it's absolutely critical that you have the documentary evidence and that you've undertaken the appropriate assessments, but most critically, that you have actually engaged with children and young people, and you can demonstrate that engagement. I think these decisions are still capable of being taken, but the route by which you get there and the way in which you are able to demonstrate your reasoning behind ultimately coming to that decision, I think will be even more important, and certainly where it's being scrutinised by the courts. I don't think we have any other questions that have come in, Fiona, and that's us on exactly 3
Yep.
o'clock.
Bang on time. There's a lot in that. I would say there's a lot in these webinars. So for those that haven't been able to attend today or want to re-listen, we will circulate the recording after today's session.
Yep, great. Well, thank you all very much for attending.
See you soon.
Bye.